Good morning, this is your Kelso Report for Monday, August 22nd. I'm your host, Clark Kelso. Well, it's tough being a teacher in California these days. Not only do you have to worry about the impact of No Child Left Behind and student testing protocols, the uncertainty created by bad budgets, the generally bad press about the quality of schools, you also have to navigate an increasingly dangerous legal minefield where a single misstep can create devastating damages liability, either personally or for your district. In CF versus Capistrano Unified School District, the Ninth Circuit considered a complaint alleging that a 20-year veteran public high school teacher violated the Establishment Clause in his advanced placement college-level class called AP Euro. The College Board standards require that the course cover a number of topics touching on religion, including changes in religious thought and institutions, secularization of learning and culture, scientific and technological developments and their consequences, and so on. Not surprisingly, in the course of the class, the teacher made statements about religion that could be viewed by some as critical of its role in historical and social development. Well, an upset student filed suit for damages under Section 1983, alleging a violation of the Establishment Clause based on what the complaint described as statements that were hostile to religion in general and to Christianity in particular. Although courts have acknowledged that it is possible for the government to run afoul of the Establishment Clause through disparagement of religion, there has never been any prior reported case holding that a teacher violated the Establishment Clause in the circumstances alleged in the complaint. Fortunately for public school teachers and other public officials, the doctrine of qualified immunity provides protection from many damages lawsuits. In particular, government officials are generally shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known at the time of the alleged violation. The Supreme Court has indicated that courts can approach the analysis of qualified immunity issues by first asking whether the alleged constitutional right was clearly established at the time of the alleged violation. This approach lets courts decide the qualified immunity question without actually having to reach the merits of the alleged constitutional violation, thereby avoiding many difficult constitutional questions. That is what the Ninth Circuit did in this case. Even assuming that at a very high level of generality, it may be possible for government to violate the Establishment Clause by disparaging religion, there still have been no reported decisions holding that a teacher violates the Establishment Clause by trying to challenge an AP class's critical thinking skills with generally recognized historical criticisms of religion's role in the development of European culture from the Dark Ages through the Enlightenment. As the Ninth Circuit noted, quote, "The Establishment Clause presents especially difficult questions of interpretation and application, and we cannot expect this teacher to have divined the law without the guidance of any prior case on point," close quote. Accordingly, the teacher was entitled to the protection of qualified immunity, and the complaint was dismissed. Well, we have quite a few one-liners. It was a busy day on Friday for particularly the Ninth Circuit. So we begin with the preemption issue in Yakima Valley Memorial Hospital versus Washington State Department of Health, where the Ninth Circuit upheld against an antitrust preemption argument the state of Washington's authority to limit the elective procedures which may be performed at a hospital to those procedures authorized by a state-issued certificate of need. The department had refused to grant a certificate of need to the plaintiff hospital to perform elective percutaneous coronary interventions, which are used to treat diseased arteries of the heart, because another hospital in the area already performed the procedure pursuant to a certificate of need, and the evidence showed there was not enough demand for two hospitals to perform these procedures. The court rejected the antitrust preemption argument because there was no evidence of an agreement. Instead, the evidence established unilateral state regulation, and that does not violate the Sherman Act. Next, environmental law. In Center for Environmental Law and Policy versus United States Bureau of Reclamation, the Ninth Circuit upheld the plan by the United States Bureau to undertake an incremental drawdown of water from Lake Roosevelt to the state of Washington for municipal, industrial, agricultural, and other stream uses. The Bureau published an environmental assessment, which concluded the drawdown would have no significant impact on the quality of the human environment or the natural resources in the affected area. The environmental assessment was challenged as being inconsistent with NEPA, the National Environmental Policy Act. The strongest basis for challenge was the analysis of cumulative impacts. However, the Ninth Circuit held that although the portion of the environmental assessment dealing directly with cumulative impacts was conclusory and unenlightening, reading the environmental assessment as a whole revealed that the Bureau understood and accounted for the cumulative effects of prior projects. As a result, the court upheld the environmental assessment and the finding of no significant impact. Next, a health law case. In Elatar v. Hollywood Presbyterian Medical Center, the Second District held that a hospital must follow its bylaws in conducting a peer review of one of its medical staff. The hospital bylaws governing peer review hearings regarding the denial of reappointment to the medical staff called for a hearing panel made up of physicians selected by an elected executive committee of the medical staff. The defendant hospital did not follow this rule, and instead the executive committee delegated the selection to the governing board of the hospital. The court held that in the absence of a bylaw provision to the contrary, the elected committee must appoint the hearing panel. It can't delegate that function to the governing board. The lesson here is pretty simple. Follow your own rules. Now, a state licensing case in Pacific Kyson and Shoring v. Bernard Brothers. The Second District held that a subcontractor who possessed a Class A general engineering contractor's license was qualified to do temporary excavation and support work on a project to construct a medical center for the county of Ventura, even though the county specifications called for an excavation contractor with a Class C12 specialty license. The C12 specialty license focused on excavation-type skills, but the court held that the broader Class A license encompassed the skills of the C12 license, and that the subcontractor was therefore qualified by virtue of having the Class A license. Having the right license is important, because a contractor who is not properly licensed cannot get paid under the contractor's state licensing law. Next, we have an evidence case in People v. Lopez, where the 6th District reversed a conviction for first-degree burglary because of prejudicially admitted evidence of prior uncharged acts of misconduct. The defendant was charged with entering the kitchen of a residence and taking 2 purses. The prior acts evidence related to a prior car burglary and prior car theft. Well, under Evidence Code Section 1101, evidence of prior uncharged acts are inadmissible to prove the defendant's bad character, but may be admitted if relevant to prove motive, opportunity, intent, preparation, plan, knowledge, identity, among other facts. The prosecutor argued the evidence of the car burglary and theft was relevant to intent. Well, the court rejected this argument because it concluded there was no dispute regarding intent. If the defendant had indeed entered the kitchen and took the purses, his intent in doing so could not reasonably be disputed. Accordingly, the prejudicial effect of the prior act's evidence outweighed its probative value to prove intent, since any additional evidence on intent was purely cumulative. Next, a class action case. In the In Re Bluetooth headset products liability litigation, the Ninth Circuit vacated and remanded for further scrutiny a settlement in class action litigation which had been brought against the manufacturer of the Bluetooth headset. The complaint alleged that the defendants knowingly failed to disclose the potential risk of noise-induced hearing loss associated with extended use of their wireless Bluetooth headsets at high volumes. The settlement agreement, approved by the district court, provided the class with $100,000 in Cy-Pray awards and $0 for economic injury, while setting aside up to $800,000 for class counsel and $12,000 for the class representatives. The evident imbalance between the class awards and awards to counsel convinced the Ninth Circuit that the settlement deserved a more searching inquiry into its fairness by the district court. I think the plaintiff's attorneys are going to have to turn the volume down a bit on their settlement. Another attorney's fees case in Rickley versus County of Los Angeles, where the Ninth Circuit held that a successful civil rights plaintiff under Section 1988 of Title 42 may recover a reasonable attorney's fee for legal services performed by her attorney spouse. The district court had denied the fees, improperly relying upon the Supreme Court's holding in Kay versus Erler that Section 1988 does not permit an award of attorney's fees to an attorney plaintiff who represented himself. And there was a subsequent Ninth Circuit holding the court relied on improperly, Ford versus Long Beach Unified School District, which held that the Individuals with Disabilities Education Act does not permit an award of attorney's fees to attorney parents who represent their own children. Both of those decisions were based on categorical determinations that the type of attorney seeking fees, in Kay's self-representation and in Ford representation by parents in an education IDAA case, was not sufficiently independent to provide effective counsel. In reversing the district court's extension of Kay and Ford to fee recoveries by attorney spouses, the Ninth Circuit noted that the district court had not undertaken a categorical analysis. And the court said, quote, "We see no reason to presume that attorney spouses are, as a general proposition, unable to provide independent, dispassionate legal advice," close quote. Next, a criminal procedure case. In In re grand jury investigation of M.H., the Ninth Circuit held that the target of a grand jury investigation must produce, pursuant to a subpoena duces tecum, certain records related to his foreign bank accounts. The records are ones that he is required to keep by virtue of the Bank Secrecy Act of 1970. The target argued that compelled production violated his rights against self-incrimination. The Ninth Circuit affirmed the district court's decision that under the required records doctrine, since he was required by law to keep these records because of his voluntary participation in a regulated activity, the Fifth Amendment right against self-incrimination simply did not apply. Sticking with banking law, in McCoy versus Chase Manhattan Bank, the Ninth Circuit, following the lead of two other circuit courts, held that the Delaware Banking Act permits a bank to impose a post-default interest rate increase on a credit card account, effective retroactive to the beginning of the payment cycle. Chase had given its customers prior notice that it reserved the power to make these rate changes, so there was really no basis for a claim that Chase had failed to give notice or had committed consumer fraud. The case was on remand from the U.S. Supreme Court, which already had held that the plaintiff's sole federal claim should be dismissed. And with the Ninth Circuit's opinion yesterday, the entire case now faces dismissal. So when you miss payments on your credit card, you can expect a rate increase. Finally, in the area of criminal sentencing, in United States versus Waters, the Ninth Circuit held that the sentence given to the defendant for possession with intent to distribute crack cocaine and possession with intent to distribute marijuana would not have changed, even though there had been a significant reduction in the sentencing guidelines for crack cocaine convictions. Under the original sentencing, his status as a career offender did not change the total offense level because the offense level was already so high by virtue of the crack cocaine conviction. After the sentencing guidelines had reduced the sentence range for crack cocaine, his total offense level dropped low enough that the career offender status became applicable, increasing his total offense level to the same level as his original sentence. Accordingly, the change in crack cocaine guidelines had no effect on his particular guideline range, and there was therefore no basis to reduce his sentence. Well, that's it for today's Kelso Report. Have a great day in the law.